Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. This video will be useful for the CPC students. Friends, we are going to discuss Order number 6, Rule number 17, that is Amendment of Pleadings. You all know what are pleadings, what is a plaint, what is a written statement, and I told you Rule 2 of the Order 6 says plead the facts, not evidence. That is facta probanda and facta probentia. I have made a separate video on this also. Now, to err is human. Baseline, to err is human. Even though I told you in Order 2, you have to, while framing the suit, you have to give the whole claim. But still, somewhere, some clerical, some arithmetical, some typical, that is a typographic mistakes will be there. And they have to be corrected. That's why amendment is a continuous process. Amendment may be necessary. Rule 16 says the court can amend, the court can strike out, the court can substitute your pleadings. That is the power of the court. But here, as advocates, you can also file amendment petitions and they will be allowed. Please remember, in the first sentence itself, at any stage of the proceedings, the court may allow, but that doesn't mean at the end stage. So, before the trial commences, please remember, you have to file the amendment before the trial commences. And you have to get leave from the court. If you don't amend it, or Rule 18 says, you can't do anything. So, normally, the court will give it time. By that time, you have to file the amended pleadings. If the court doesn't give any time, within 14 days, that is 2 weeks, you have to file the amendment. Later, it will not be accepted. This is Rule 18. So let us confine to Rule number 17. So please remember, the amendment of pleadings is not exhaustive power of the court. No doubt, you have to obtain permission. Leave of the court is necessary, right? The power of amendment is inherent in the court. Even section 152 of the CPC, 153 of the CPC, they say, yes, the clerical and error mistakes and general power of the court to amend. When we go to that sections, I will explain you in detail, but they are also applicable for the amendment of your pleadings. Before that, the court has to consider 2 points, most important points. Whether the requested amendment or whether the amendment sought is necessary for proper and effective adjudication of the subject matter in the dispute, whether it is necessary or not. Second point is whether it will cause injustice to the other party. This is more important. Suppose if the injustice is caused to the other party, definitely the amendment will not be allowed. Third party, by way of amendment, you should not disturb the basic structure. That means, suppose if it is a case of sharing properties, that is sharing property, if you file a civil suit for sharing your properties, so the subject should be regarding the shares only. You should not, by amendment, you should not go to the declaration of the title. So the original framework should not be disturbed, right? So the other party should not be done to the so-called injustice. This is the most important point. So in the case of Kishan Das versus Rachappa Vitoba 1909, please remember, all amendments should be allowed when, number 1, if it is not doing any injustice to the other side, and when it is necessary for the purpose of determining the real questions in controversy between the parties. This is what I told you just now, right? So please remember, in so many cases, amendments are being allowed. We have been seeing the advocates filing the amendment petitions 4 times, 5 times, but certain times they will be refused also. Please remember, in the case of Gangabai versus Vijay Kumar, 1974, please remember, the Supreme Court has clearly observed that The power to amendment is definitely, undoubtedly wide. And please remember, the exercise of such discretion or far-reaching powers, they should be decided by judicial consideration whether injustice will be caused to the other party. Right? So this has come from the time immemorial. So the very purpose, the interpretation clause or the very purpose is that nobody is perfect in this world. To err is human. That human errors should be corrected but the merits should not be changed. And please remember, please remember in writ petitions, already I told you the pleading should be more clear. Amendments, normally they may not be granted. Please remember, right? So, this amendment is very, very important. So, in writ petitions, Article 226 or the 227, normally a High Court will not give permission for the amendments, right? So, the amendments can be applied even in the appeal stage also. I have seen one case, I don't remember that case law. 1 minute, let me tell you. Amendment, leave to amend will be refused and application for amendment is not made in good faith. Okay, so even in the appeal stage also it will be allowed. I do not remember the case law. I will get it in time. Of course, I will tell you in the class. So please, this is the actual topic relating to the amendment of pleadings, which will be very useful for you during your practice. So please read order number 6, rule number 16, 17 and 18 and remember them perfectly, because they will be very, very helpful to you in your practice as a civil advocate. Okay, with this I am concluding. Thank you very much.